Good evening to all. Today we are going to have a session to understand how to evaluate and interpret a double taxation avoidance agreement, one of the most critical areas in the study of international taxation. So we are honored to have Chartered Accountant Vispi Patel as our speaker for the day. Thank you, sir, for taking your time out for addressing us on this topic. So about Vispi sir, he has 40 years of experience and expertise in the direct taxation, including international taxation, transfer pricing, and he has been closely associated with the development of transfer pricing law in India. He's a prolific author and has contributed articles relating to international taxation, mutual agreement procedure published in India and abroad. We look forward for your inputs on this topic. Thank you so much, sir. Before handing over the session to the speaker, a welcome address will be there from Piyush sir, the chairman, Direct Tax Committee of ICAI, followed by opening remarks by Kota Srinivas, vice chairman, Direct Tax Committee of ICAI, and then an overview of the session will be given by Mr. SP Singh, ex-IRS. So over to you, Piyush sir.
Thank you. Very good evening to all of you. Thank you very much, Rani NR. Very good evening to all the participants. Respected speaker, a very senior speaker, Vispi Patel Sahab, SP Singh, moderator for the day, Rani NR. Along with me, my vice chairman, CA Kota Srinivas, Central Council member from the Bangalore. My warm welcome to all the participants to this fourth webinar for this council year. You may all be aware that this council year started on 12th of February. And in month of March, the committee decided that every weekly webinars we should have. One on direct tax, 1 week, every Thursdays, you will find such webinars happening between 4 to 6. So 1 week we do on direct tax topic, on 1 week we do on international taxation. When I speak of today's speaker, Vispi Patel Sahab, who is my elder brother, obviously he is expert in international taxation and he has been always available to the profession. I am seeing him the days when I started my professional career, when he used to argue in ITAT on the international tax matters. And anybody in this profession, especially when I come from Mumbai, the same city from where Vispi Patel comes, any member in the Mumbai city, if you tell him about the Vispi Patel, I am sure they would be overwhelmed to listen to him. And they've been looking forward to him to study the international taxation, to see how he presents the paper, to see how he argues. So thank you very much, Vispi Patel Sahab, for accepting our invitation. Thank you very much. Rani ji, thank you very much for agreeing to moderate this session. And thank you very much. We appreciate your time given for this DTC. Thank you very much. SP Singh Sahab is our heart of DTC. He has been always available. He is contributing a lot towards the pre-budget memorandum also, which we are working concurrently now. And we expect to present this pre-budget memorandum before the CBDT chairman and the tax policy, maybe in the second week or third week of the April, depending upon when the discussion takes place. On this pre-budget memorandum, we are giving varied suggestions on the topics of direct taxation, on the provisions of the direct taxation, on the provisions of the international tax law. And generally, as a practice, the CBDT chairman, along with the policy-making wing, they give us an opportunity to present our whatever suggestions are there. So when we give suggestions, we also give the existing provisions of the law, what are the amendments which have been sought, and what is rationale behind this. My request to all the participants, whether it is on a direct tax topic or whether it is relation to international tax, if you have any suggestions to be included in pre-budget memorandum, my request to you would be to please write to us on dtc@icai.in. We have already drafted one pre-budget memorandum which has been circulated amongst the experts of direct tax and international taxation across India. I am sure they will receive their comments also, which will be included and presented before CBDT. All the participants are requested, please do write to us if they have any particular suggestions. In a format, as I mentioned earlier, please do give any suggestions along with the rationale. Only because if you are giving a proper rationale, it can be understood by the policy making and the chances are that they will be accepted well. During this year, as I mentioned in my previous webinars also, that the Committee for the Direct Tax and International Taxation, which hitherto were two committees of the Institute, since last year they've joined and now it's only one committee. which looks into both direct tax topics as well as international tax matters, basically. So this year we have decided to come out with the research papers, and we had also invited expression of interest from certain people who have been associated with the institute or a direct tax committee, or who have completed or shown interest in the international tax subjects for writing a research paper on certain 4 or 5 topics, such as on taxation of digital economy, then on scope of tax on royalties and FTS, foreign tax credit, and methods of computation and ELP. So we have already written some, we have already got some expression of interest from certain members. We would request all the participants who would be interested in writing or associating with the Direct Tax Committee of ICI for writing research papers on these topics. My request would be, please do write to us. We'll try to include them. We want to nominate those members and make a research paper within 3 to 4 months. This is one of the important agenda item for this particular year of this Direct Tax Committee. Other than this, as you know, Institute conducts diploma in international taxation. These courses are conducted in the physical mode as well, and also in an online mode. Another course which has been going to be launched would be starting from 1st of April, a diploma in international taxation. There is a limit as per the council. Maximum participants can be 200. We have already received 194 applications, and there are already more in the pipeline. I believe those will be closed. But I am sure during this year, further courses will be launched on an online mode and maybe a physical mode also. If any of the members would like to attend those online courses, would like to register for them, please do register. This diploma in international taxation course is very well recognized, and there is also an examination which happens after the course is completed. And this examination is conducted in the similar manner as if the CA examination is conducted. It is completely done independently by an exam committee and not by the direct tax committee. So it's a very independent examination, and it's quite a good examination. And I'm sure a lot of members have benefited, and we always get a response. Whenever we launch such courses, it is always completely jam-packed, whether it is an online mode or it's a physical mode. We will be also trying to conduct these courses in various cities, maybe metros or tier 2 cities, subject to a minimum participation being 40 or 30 respectively. On a physical basis, because we have an experience that a lot of members keep on requesting that such courses should be on the physical mode. So we'll be doing that. So my request to you, please keep a watch for it on our website. I'm sure it will help you in registering for that. So with this welcome, I once again welcome you all the participants and request you to be attentive for next 2 hours. 1.5 hours, and then there would be a question and answer session. I'm sure you will cherish when Vishnu Patel speaks on this international taxation, and I'm sure very well it would be moderated by Rani NR, and I think so it would be a great learning for all the participants. So once again, very good evening, and I would now hand over again back to Rani NR to take it forward. Rani ji, over to you.
Yeah. Yes. So now we will have opening remarks by CA Kota Srinivas, who is the Vice Chairman of Direct Tax Committee of ICA.
Yeah, thank you, Rani. Good afternoon, the speaker for the day, CT Patel, the Chairman of Direct Tax Committee, Piyush Chajed, the moderator for the day, Rani NR, and our, I should say, the helping and always, SP Singh sir, who is always with the Direct Tax Committee, and all the participants who have joined for this particular webinar. As the chairman said, am I audible?
Yes, please.
Yes. Yeah. As the chairman said, we are conducting this particular webinars every week on Thursday, 1 week on direct tax and the other week on international taxation. Today we have a session on evaluating and interpreting a double taxation avoidance agreement by a senior member, T. Patel. As all of you are aware, this international taxation has evolved over a period of a number of years as such. In fact, initially it was a very, very small topic in the income tax. It was a branch in income tax, but today, if you see, it has grown like a very big banyan tree. It has got a lot of things to analyze and see interpret this particular international taxation. Maybe after the liberalization started, maybe 1991, a lot of things improved, and India uh, got into this world map with, dealing with the transactions with various countries in the world. In fact, this double taxation award settlement, India may we have around 195 countries, but as of today, India would have entered into DTA with around 90 to 95 countries. But in that, majority of the developed nations or developing nations, India has got a DTA. Earlier, maybe it was only one type of transactions between the countries, that is import or export of goods as such. But with the advent of technology, improvements in the technology, and even improvements in the transportation media, now but it is not just the goods. Even the services will be imported and exported. There'll be funds, finance, which will be received from different countries, and of course the movement of people will be there from one country to another country, and even intellectual property and so many other things. Now with this e-commerce being, there may be n number of transactions between the countries as such. Even though politically most of the countries may say that they're all independent, but they have to depend on other countries for various things, whether with respect to the services or goods as such. And as I said, with the invention of technology, like there are a lot of transactions between the countries, and a lot of these articles which was there where the DTAs have been entered in maybe in the early 50s or early 60s or later 60s, in the year 1970 or something like that. There are a lot of changes with each and every article, and now with the BEPS and things are coming, even the definitions of some of the things have been changed. Like P definition also has been changed. It has got a very very wide scope as of now. So now it's very good that we are starting with this year's webinars with interpreting double taxation avoidance agreement. I am sure that with the wide experience and expertise of Patel sir, he will take us through how to interpret a particular DTA as such. There are various articles in DTA, as all of you are aware. Maybe it depends upon 30 to 31 articles, and it's almost structured. Like Article 1, what is that? Article 2, what is that? So we have various articles which deal with the income aspects. So I hope Sir will take us through all these things. And as we know, every week we are doing conduct. So in this year, we may be conducting another 30 to 40 more webinars. In that, 50% is international taxation, means around 20 we'll be doing. So we'll try to cover as much as possible each and every article in this particular webinar so that we can understand in detail. And this will help the members who are not into international taxation or who are wanting to start take up this international taxation as a practice this thing. So you can attend these webinars, and also as you said, you can attend this diploma courses and know more about the international taxation. I wish all of you happy learning and a start for this international tax learning for this current year. Thank you, Rani, for moderating this particular session. uh, Now over to you.
Yeah. So now we will have Mr. S.P. Singh, sir, ex-IRS, to give us a brief overview of the session. Over to you, sir.
Good evening, friends, and thanks, Rani. Uh, First of all, I would like to thank the ICAI, and particularly Piyush ji and Kota ji, for starting this weekly webcast of important topics in the area of direct taxes, including international taxation, which obviously includes transfer pricing. Today's topic, evaluating and interpreting a double taxation avoidance agreement, is I would rate is one of the most important topics. Now, I will take a couple of minutes to share my views about this topic. As you know, this DTAA, or the Double Taxation Avoidance Agreement, is unique in the sense that though it is negotiated, finalized by the executive, that is the tax authorities, it becomes part of the tax law, which is actually enacted by the parliament. Not only this, under certain circumstances, the provisions of the DTAA even supersedes the provisions of the income tax law. Now, this makes the tax treaty a very unique tool, and it is very important for the practitioners in international taxation to know how to evaluate and interpret a double taxation avoidance agreement to a certain set of facts. So far as the talking about this topic is concerned, I, I totally agree with Piyush ji and Kota ji, is that there cannot be a more competent and suitable person than Vispi, CEO Vispi Patel ji, to talk about this. I know him for more than 2 decades. He has the vast experience of working on international taxation for approximately, or rather more than 3 decades. So he knows the subject, and he is known for sharing his knowledge, his experience with the students of international taxation. I am sure it will be a very great learning for all of us. So far as the DTA is concerned, let me share some thoughts. International trade, or the long distance trade, has been in existence for many centuries, even during the prehistoric period. There are evidences of trade taken by the people who were living in Indus Valley, in the Mesopotamia, and all those locations. Now, this increased during the medieval period, and Marco Polo's name comes to our mind whenever we talk about international trade in the Middle Ages. Industrial revolution and development of banks are the two great factors, of most important factors, which has given rise to the emergence of multinational enterprises. And the two countries which had, uh, rather, I would say the two countries which were in the forefront of industrial revolution and development of financial institutions, particularly bank, were England and the Netherlands. And that is why you find the first two multinational enterprises being incorporated in England and the Netherlands. In England, it was the British East India Company, which was started in 1600, and the Dutch East India Company, which was started in 1602. A lot has happened since the inception of multinational enterprises. The development in technology, in communication, in financial transactions have made the world very small. We call it globalization. The economy of all the countries across the globe are now integrated. And the factor, or the carrier, or the motivator, or the engine of this integration are the multinational enterprises. They are supported by the development in technology, in communication. And what we now observe is the fourth phase of the development, and that is the digital emergence of the digital economy. The digital economy is challenging all the established concepts regarding the taxation. And the other factor which has proceeded or developed along with the emergence of the multinational enterprises is the policy of the taxation adopted by the various countries. And as you all know, and I'm sure Vispi will be talking about that, that the two most common rules are the source rule and the residence rule. And every country is very attached to their revenue because they have to take care of the rising aspirations of their population. So increased enforcement is resulting in double taxation. And as you can appreciate, double taxation is not something which anybody will appreciate. So the world has been trying to find a solution to that. And the first tax treaty was signed between Prussia and Saxony sometimes on 16th of April 1869. After that, approximately 30,000 tax treaties have been signed by various countries. One challenge which the negotiators of the tax treaties have been finding is how to have a common uh, thing to start with. And all the negotiators have taken help of the models which have been developed by the OECD to start with, right from the 1963, and which has been carried forward in the subsequent amendments or modifications in the model tax treaty, and also by the UN. The greatest advantage of having model, uh, so far as the tax authority is concerned, they have something to start with, a common knowledge, language, a common approach regarding the taxation. So this helps the tax authorities, the negotiating teams, a lot. Now, so far as the taxpayer is concerned or the tax practitioners are concerned, if you understand the tax treaty and the commentary there too, you understand almost 75 to 80% of any tax treaty entered into by between any two countries. The 25% is the deviation on which you have to focus. This has been very great help. And the tax treaties, as I said, have been very great, and not only help, not only in reducing or eliminating double taxation, but in many aspects, in providing the best possible platform for the multinationals to operate across the globe. But there are certain challenges also. The difference in interpretation between tax authorities and the taxpayers have given rise to litigations galore. Particularly if you take the cases of the transfer pricing, which contribute almost 75% of the tax litigation across the globe and even in India. So one need to understand the basic tenets of the tax treaties or the double taxation avoidance agreement. And we are very fortunate to have Wispy with us, who knows what the DTAA are and how they are to be interpreted in a very cohesive and effective manner. So I'm sure all of you will love hearing to him and will definitely raise questions. If there are certain questions which remain answered, the Secretariat will be very happy to follow up. So over to you, Rani, for further proceedings.
Thank you very much, sir, for that brief introduction of the session. Now, we all look forward for the session from Wispy, sir. Over to you, sir.
Good afternoon, my friends on the panel, Piyush, Mr. Singh, Mr. Kotha, Rani, and all the support staff, Priya, Rudrakshi, everyone. I share the screen now, Rani, with my presentation.
Yes, please go ahead. Please go ahead, sir.
Okay.
It's visible, sir.
Yes.
It's visible.
Did you, Piyush, you said something?
No, sir. It's okay. It's visible. She said. Rani said. You can continue.
Yeah, please go ahead, sir.
Yeah, I'll go ahead. Thank you. I don't know. I'm getting this 1 minute, huh? Some issue is there. That's it. Fine. So, good afternoon, friends, and I hope we have a happy learning session and try and understand what is a tax treaty. So, I'll take you through, so I'll try and introduce to you what is the concept of a treaty, principles of interpretation, a case study, so it can help us to understand how do you actually interpret a treaty, then significance of the preamble, aids to interpretation, what is this most favored nation clause, extremely litigative, and the latest development in international tax is the signing of the multilateral instrument, and how does it modify a treaty. So on that basis, we'll try and conduct this whole session, and I hope you find it an enjoyable process. So as far as the tax treaty is concerned, let's try and understand what is a treaty, what are the objectives of a treaty, what are the different types of tax treaties. As you are aware, there are various types of international treaties. We are only going to study a tax treaty. So you have, for example, different types of treaties to share water. You have treaties where for trade purposes, you have treaties for defense purposes, you have treaties for so many reasons. We'll focus our attention to tax treaty. What is the treaty position in India? What does our constitution say? What is the difference between a piece of legislation and a treaty? What is the general structure of a treaty and the articles? So, a tax treaty is a formally concluded and ratified agreement between two sovereign nations. Very important. They are known as bilateral treaties. Or if you have more than two nations, then it is a multilateral treaty. That is why the multilateral instrument, the MLI, is whereby countries have got together to try and modify the treaties on a quick basis, because negotiating with different treaty partners takes lots of time. So from where does this treaty making power emanate, and what is taxation, and from where does that emanate? Every sovereign nation has a right to tax its residents and nationals on a worldwide tax basis, and non-residents based on their nexus with their country. So, in the country of residence, tax is a cost. Tax is an obligation, sorry. While in the case of a host country, when a non-resident has a nexus and his income which emanates from the source country is taxed, then to that extent it is a cost. So therefore, to avoid double taxation, whereby a non-resident pays tax in the country of source, and then again he is taxed in the country of residence, to avoid that, to try and give a level playing field, to encourage international trade and commerce, double taxation avoidance agreements are entered into by two sovereign nations. You can call it a DTAA, you can call it a tax treaty, or you can call it a DTC, or you can call it a treaty. So what is the objective of tax treaties? One of the most important objectives is to avoid juridical double taxation. What is the meaning of juridical double taxation? Means the same entity getting taxed twice in the country of source and in the country of residence. So therefore, to avoid this double taxation, what does a tax treaty do? It allocates taxing rights to different types of income to the two treaty partners. At the same time, a treaty is also entered into to prevent fiscal evasion. A treaty cannot be used or should not be used to evade taxes. That is what is a principle which is emanating nowadays. Then exchange information about taxation matters between two countries, so that there is no leakage of tax revenue, either in the country, in the host country, that is a country of source, or in the country of residence. Then one of the objectives of a treaty is to be impartial. There should be no discrimination between residents and non-residents. There is a dispute resolution mechanism embedded in the treaty beyond the one which is available in domestic law. Assistance in collection of taxes, that is to be, so that there is equity and fairness, treaties are entered. There is complete neutrality between capital export and import. That is at least the motive or a philosophy of the treaty. Whether it achieves that or not is for us to try and imbibe and understand. Provide, give efficiency. And one of the most important reason is that when you try and avoid double taxation, both juridical and economic double taxation, you promote mutual economic relations and trade and investment. So you have different types of tax treaties. In the initial days, you used to have very limited tax treaties, like to cover income from operation of aircraft and ships, estates, inheritance, and gifts. And nowadays, we enter into what are known as comprehensive treaties, addressing all sources of income. This is a very important slide. What is a treaty? A treaty is a negotiated, ratified instrument between two countries. So it's an agreement. So it is contractual. So what is the biggest difference between a tax treaty and domestic law is? Why do you pay taxes? Because the burden is cast on you, that is the citizen or the person who earns income in India, by a piece of legislation. And from where does the piece of legislation emanate? It emanates from the Constitution of India. That's the important part. While a tax treaty is an agreement, so it's contractual. And therefore, it involves public international law. It involves a negotiation process. It's relief from double tax. It tries to share revenue in a reasonable, amicable manner between treaty partners. No, you don't find many frequent changes, and disputes are settled either through the domestic law, that is the appellate forum, court, or the dispute resolution mechanism, which is embedded in the treaties, which is the mutual agreement procedure, and nowadays in the modern world, through arbitration. What is a domestic law? So power to tax is the birthright of every sovereign nation. And you can see that taxation was there in thousands of years ago, when people had to collect taxes so that the governments could run. So it's an act of legislation under the Constitution. But remember, tax treaties are also entered into because the power to enter into the treaty also emanates from the Constitution. But the power to legislate and collect taxes is not embedded in a treaty. It is embedded in the domestic law or the municipal law. There is no negotiation. The law is cast, the law is passed by the parliament, and the law is implemented by the executive. That is the tax department. So there is no negotiation. There is a charge of tax. There is earning of revenue and frequent amendments, which is the bane of our Indian system. The amount of amendments which are there embedded in the 1961 Act, I mean, there is a plethora of amendments. Why? Because probably the executive and the parliament try and curb and try and believe that they try and plug in all tax loopholes. But is that the most correct method? Is that the more favorable method? And answer is no. And you should read Mr. Palkhiwala for that, the original Mr. Palkhiwala, 7th and 8th edition, where he talks about this bane of completely, always with every budget, bringing in hundreds of amendments. And dispute is settled through the appellate forum and the courts. So what is the construction of a treaty? So the construction of a treaty is, there is a scope, there is a definition, there is taxation of income, capital, provisions for elimination of double taxation, special provisions for anti-avoidance, like limitation of benefit article, miscellaneous provisions, and then you have protocols and termination. So I've just taken the India-UK TTAA as an example to try and make you understand what are the different types of provision. So there's the scope provision. Who is covered? Article 1. Which taxes are covered? When does it enter into force and termination? Then there are the definition sections. Article 3, Article 4 for fiscal domicile residence, Article 5 for permanent establishments. Then you have anti-avoidance measures. That is Article 10, which is the transfer pricing article of associated enterprises. Exchange of information, tax examinations abroad, assistance in collection of taxes, and LOB, that is limitation of benefits. And to eliminate double tax, you have Article 24, that is elimination of double taxation, and the MAP process, mutual agreement. And then you have miscellaneous provisions, Article 21 for students, 22 for teachers, 26 for non-discrimination, non-discrimination between a non-resident and a resident, and diplomatic and consular services. The most important articles are the distribution articles of income. That is Article 6 to 23, except 10, 21, and 22. So in this, all the various types of income from different sources are covered, from property, from business, air transport, shipping, dividends, interest, royalty and fees for technical services, capital gains, independent personal services, dependent personal services, that is employment, directors' fees, artist and athletes' income, government remuneration and pensions, pensions and annuities, and of course, the residue article, other income. What are the important principles of interpretation of a tax treaty? We have already studied, I have pointed out to you that a treaty is a negotiated agreement, while a law, a taxation law, is a piece of legislation. It requires you, it commands you to pay tax. A treaty does not have the power to tax you, it actually relieves double taxation. That is the most fundamental principle which distinguishes a treaty from domestic law. So what is the difference between interpretation of a piece of legislation and an agreement? So first is, a treaty is the language of a diplomat. It is not the language of a draftsman. First and most important is that it imbibes the intention of two countries of how to conduct trade and how to relieve double taxation. Treaties use terms which are not used in domestic law. And therefore, to interpret a treaty on the basis of the principles which are enshrined in our jurisprudence based on our constitution of how do you interpret a piece of legislation, because it's a burden cast on the citizen, on the taxpayer. And these principles and procedures cannot be used as a cloak to interpret a treaty. Treaties are more generally worded and they lead to, and the important thing is that it should not lead to double taxation or double non-taxation, both. So what is the basic rule of domestic law? Jurisprudence tells us that any piece of tax legislation, unlike a welfare legislation, a taxation legislation like direct tax, income tax, for example, we used to have wealth tax, we used to have gift tax, we used to have estate duty. Any type of direct tax law has to be interpreted on the mere language of the legislation. You will not add a comma, you will not add a full stop, nor will you omit a word, nor will you add a word. That is the literal interpretation, which is the original interpretation and which is the most favored interpretation of a piece of taxing legislation. Of course, over a period of time, some different methodologies, depending upon which section you're interpreting, which if a section gives some benefit, how do you interpret a section which gives a benefit to the taxpayer or gives him some leverage, a leeway? So sometimes the purposive method of interpretation is employed, or the golden rule or the mischief rule is applied to to try and interpret a piece of legislation on the basis of its purpose or intention, provided that the clear language of the legislation is ambiguous. So the most favored way is always to interpret the law, the domestic law, the municipal law, on the basis of the language itself. But how do you interpret a, a treaty which has been well enshrined in jurisprudence, well documented, and well commented upon in Azadi Bachao, where they quoted the commentary of Francis Benyon that the interpretation of a treaty imported into municipal law by indirect enactment, which is in our case, section 90, subsection 1, that when a treaty is notified, it gets assimilated into domestic law, is described by Lord Wilberforce as being unconstrained by technical rules of language or by English legal precedent, but conducted on broad principles of general acceptance. Words are to be given their general meaning. How you, a normal man, a normal businessman, would understand a treaty, a language of the treaty, the meaning of the diplomat and not of the lawyer. So interpretation to take care of consideration that what was the basis of the negotiation, what was the intention of that particular article, and has it, and does the interpretation lead to the fulfillment of that intention? So it's contractual. How do you interpret an agreement under the Contract Act? You interpret it on the basis of the intention of the parties to the contract. Similarly, a double taxation avoidance agreement, a treaty, should be interpreted on the basis of the intention of the two sovereign nations. So what are the general principles or the important principles of interpretation which are applicable to tax treaties? Principles enunciated by the International Court of Justice at Hague. Tract treaties are a legal obligation for the contracting states from the point of view of public international law. But remember one thing, very important. They may be an obligation to the contracting states, that is the executive. But till the treaty, even ratified by the Union, is not assimilated into domestic law, through Article 253 of the Constitution by a piece of legislation, that treaty is worthless. Because the municipal law, if it does not enact the treaty, the courts and the tribunals will not give effect to the treaty. So the binding nature of these principles on domestic courts and taxpayers depends upon the Constitution, on the rules of constitutional law. We'll look at it as we continue. So the Vienna Convention of Treaties, of the law of treaties, is important because it's a codified basis of public international law. It's codified. So therefore, they define a treaty as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in a particular designation. And in the interpretation of treaties, the three very important articles are Article 31, 32, and 33 of the Vienna Convention, which for short form we'll call it the VCLT. A VCLT is binding on the states. But in the Supreme Court in Ram Jethmalani says that as the VCLT codifies customary international law, it is also relevant on non-signatories. This is important. Not binding, but relevant. And we will see the evolution of treaty law, of jurisprudence, how they will apply the principles of VCLT, how they will apply other principles of public international law like the OECD commentaries, the UN commentary. We'll have a look at it. And therefore, even non-signatory nations are affected by the VCLT. The most important article is that Article 26 is that treaties are binding on the contracting. states, that is the two sovereign nations, and must be performed, very important, by them in good faith. Any contractual agreement between two contracting parties has to be, and law establishes that they have to be performed in good faith. Treaties are not a piece of legislation, and therefore they can never be retroactive. So you have retrospective amendments to the income tax law, and they have to pass muster of Article 14, that is non-discrimination, and other articles wherever they are applicable, like Article 19, before they can said to be retrospective in nature, and there is a lot of litigation on that. But treaties generally, normally, mostly are never retroactive unless it so provides and both sovereign nations agree to that situation. What does Article 31 say, which is very important, the basic rule that a treaty first should be interpreted in good faith. And these are the most important words, in accordance with the ordinary meaning to be given to the terms of the treaty in their context. Context means context of the words where they are embedded in the treaty and in the light of its object and purpose. Remember, it's an agreement, and therefore a treaty has to be interpreted not only on the language, yes, on the language in the context, but to give effect to the objects and purpose. So, what is the meaning of context? Context means what is the text of the treaty, what is the preamble and the annexes. So, for example, you have a memorandum of understanding attached to the India-US double taxation avoidance agreement. That's like an annex. You have protocols sometimes, which tend to give effect to a treaty. You have, therefore, the agreement relating to the treaty made in the past can give you a little context. An instrument related to the treaty made and accepted by one or more parties in the past can also give you the context of the treaty. And context is very important. In addition to the context, following should also be considered. That is what Article 31.3 says of the VCLT. Any subsequent agreement made between the parties regarding how a treaty has to be interpreted means both parties agree that we will come to some sort of an understanding. So therefore, you have sometimes a memorandum of understanding, sometimes you have a protocol. Any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. So any practice, any relevant applicable rules of international law applicable in relations between the parties. And a special meaning may be assigned to a particular term if that is so what the parties intend. Now, this is the controversial part, is that what happens to terms which are not defined in the treaty? So Article 3.2 of the Model OECD Convention says that terms which are not defined in the treaty may be understood from the meanings given to it in the domestic law, provided, that is very important, that they are within the context of the treaty. So you cannot pick up a definition of a particular source of income as defined in the domestic law, which does not go within the concept of the treaty in the basis of the context of the treaty. So there is a limitation, but sometimes the tax department believes that terms which are not defined in the treaty will always carry the definition as per domestic law, which is not the correct basis of interpreting a treaty. You may use the domestic law definition provided it is within the context of the treaty. And you will only use the definition in the domestic tax laws and not other laws. So jurisprudence tells us from the Supreme Court that meanings can be ascertained from domestic law where the term is not defined in the tax treaty. Remember the limitation, it has to be in the context of the treaty and for the purposes for which the treaty has been signed, the intention, the purpose. So under Section 93, India has tried to define. Jurisprudence will tell us whether these definitions are binding or whether it is an unilateral act, because whether the other treaty partner has agreed to such a definition is also to be considered. So let's try and understand now how you would interpret a treaty vis-a-vis the domestic law. Very interesting case in UK. It's between the case study is between South Africa and the UK treaty. So what is it? This is also available in 116 taxman. So we have to refer to section 6(5) of the Income Tax Earnings and Pension Act, which defines employment, and section 15(2) of the Income Tax Trading and Other Income Tax Act, which defines what is trading and business income under UK law. And you have to read these two sections along with Article 3(1) of the DTAA, which defines various definitions, and Article 7 of the DTAA, that is business profits, and Article 14, which is dependent personal services, income from employment. So what happened over here? A South African resident went and earned income from diving activities conducted in the UK. This is the mere fact of the case. Now let's try and understand what happened. So what does this case law tell us? To what extent does the treaty allow the deeming provisions of the domestic tax law to affect the meaning of the words of the treaty? Very important. To what extent can a deeming fiction of domestic law govern the interpretation of a term of a treaty? And the extent to which deeming provision can amend the meanings of the terms of the treaty. Very interesting. So let's try and understand. So the assessee undertook diving engagements, extremely risky, extremely full of hardship in the UK continental shelf. So the UK, to encourage foreign divers to come and try and help UK to become energy self-sufficient, said that if you come and perform these services, even through a contract of employment, it will be deemed to be trading income. And therefore, these diving activities were to be treated not as income from employment, but were to be treated as income from self-employment, means like a business income. And therefore, the question that arises is that whether for treaty purposes, the terms not defined in the treaty need to be understood as defined in the domestic law. And therefore, the argument of the assessee and His Majesty's government was whether you will apply Article 7, which deals with business profits, or whether you will apply Article 14, which deals with income from employment. Because he earned this income from a contract of employment, though under the domestic law, it was deemed to be business income. So what did the first tier say? Wait, they said, Section 15 of the ITOIA, that is the Trading and Other Income Act, very clearly says that this is to be treated as business income, and therefore you should apply Article 7 and not Article 14. The upper tribunal gave a different contrary view and said that no, it may be that the deeming provisions of the domestic tax law say that you will be treated as, it should be treated as business income, and therefore you can avail of various deductions and pay tax on that basis. But from a treaty perspective, it is still income that emanates from employment, and therefore Section 15 would be applicable of the income from employment. And therefore Article 14 should be applicable and not Article 7. So they overturned the decision of the first tier tribunal. So you can consider first tier to be like a Commissioner of Income Tax Appeals or a DRP and the upper tribunal, like our ITAT. So the Court of Appeal reversed this decision and said that what the first tier said, that it is to be treated under the treaty as business income, and therefore Article 7 would apply, is correct. His Majesty's Revenue did not agree. They went in appeal to the Supreme Court and said that no, the income which Mr. Fowler has earned, though under the deeming provisions of the domestic law of UK, may be treated as business income, but in reality, when you interpret the treaty, you will give effect to Article 14 and not Article 7. So what was the contention of the assessee before the Supreme Court? That the assessee contended that Section 15 of the ITOI classifies a diver under trading activities. And therefore, when you interpret the treaty, please go back to Article 3 to interpret the treaty in a manner which is in consonance with the domestic law. That means the actual earnings of Mr. Fowler from his employment must be regarded as profits, or more accurately, as receipts which form part of a computation of a trading account of the trade which he is now deemed to have carried out. So he is deemed to have carried out a business of deep sea diving in the continental shelf of UK. And therefore Article 7 and not Article 14 applies. What did the Honorable Supreme Court of UK say? Very interesting. It says that which of the articles, Article 7 or 14 would apply, would depend upon the true construction of these articles or those articles. In the context of the treaty as a whole and its purposes, with the meaning of the terms within those articles, ascertained as required, if necessary, by Article 3(2) by reference to UK income tax law. What does it go on to say? That nothing in the treaty requires that Article 7 and 14 have to be governed by the deeming fictions created artificially under the domestic tax law of UK. Rather, they are to be applied to the real world, unless the effect of Article 3(2) is that you can amend the complete construction of the treaty by incorporating the deeming fictions by using Article 3, which they said is not relevant at all. The Supreme Court also referred to the OECD commentaries and along with Article 31 of the BCLT and said that you have to interpret a treaty in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. So therefore, you cannot incorporate, you cannot say that the artificial deeming fiction of domestic law will govern the interpretation of the treaty. We looked upon this at the original point itself, that a piece of legislation is different, a treaty is different. A piece of legislation is the right which has been given by the Constitution. So the Parliament can enact the Income Tax Act so that you can tax income earned by the taxpayer. But the principles of that interpretation and principles of that law cannot cloak the interpretation of a treaty. And the HMRC's appeal was allowed. Similarly, in a ruling by the Supreme Court of Canada, it held that an important consideration while interpreting a tax treaty is its dual nature, contractual and statutory. How does it become statutory? When it gets assimilated into domestic law or municipal law of that country. So how does our treaty get assimilated and become a part of the statute? Through Section 90, subsection 1. Subsection 4 says, subject to the provisions of the Act, tax has to be paid on income. Section 4 is the charging section. So subject to the provisions of the Act includes subject to provisions of Section 90, subsection 1. So consideration of the contractual element is crucial because it focuses on the analysis that whether the tax planning strategy of the taxpayer fits within the terms of the treaty. So therefore, the ruling held that one must consider the ordinary meaning of the text in its context and in the lights of its purposes. However, unlike statutes, treaties must be interpreted with a view to implementing the true intention of the parties. So this is the basic difference between domestic tax legislation interpretation and treaty interpretation. The Bombay Tribunal also in the case of Blackstone held, what did it hold? Based relying on the ruling of the Canadian Supreme Court, that can you interpret the treaty in a manner that if the particular article does not talk of beneficial ownership, can you read words into the treaty? And what does it say? It went on to hold that Article 10 or Article 11 of the Indo-Mauritius Treaty, which deals with income from interest or dividend, talks of beneficial ownership. But Article 13, which deals with capital gains, does not talk of beneficial ownership. And therefore, you cannot read the provisions of beneficial ownership embedded in Article 10 and 11 into Article 13. And it said it would thus seem possible that reading a beneficial ownership test, when such a test is not embedded in the treaty provision itself, would mean that you're rewriting the treaty itself. And that is never allowed. Now we come to how do we interpret a treaty? And one of the important principles is that a preamble does give rise or does tend to tell us what is the intention of the parties. And therefore, the preamble, as the preamble of the Constitution is critical, which says that we, the people of India, having solemnly evolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all of its citizens justice, liberty, equality, fraternity. So like how the Constitution has a preamble, even the treaty has a preamble. So preamble is like an introductory statement telling us why we have entered into the treaty. It sets forth the objective or purpose of the treaty and serves as an aid to interpretation. However, remember one thing, where the text is plain and clear, then the preamble cannot change the meaning of the plain text and which is clear of the text which is plain and clear. And the text has to be considered in its ordinary meaning, just like a marginal note in a piece of domestic legislation under the Income Tax Act cannot govern the interpretation of the section if the words are clear, though it may sometimes give indication to the object of that particular section. So the preamble does play a critical role, and we will see how this preamble has now changed under the MLI, that is the multilateral instrument, and how it affects interpretation of a treaty. Even Article 31 of the VCLT says a treaty shall be interpreted in good faith in accordance with the ordinary meaning for the purpose of interpretation. It specifies that even the preamble shall be included. What does Article 6.1 of the MLI now state? So this is completely different now. The new preamble is completely different from what the Supreme Court interpreted in Azadi Bachao, and it will now depend on how jurisprudence will evolve, how we would interpret a treaty merely on the basis of the preamble. So Article 6.1, once it is embedded in a covered tax agreement, which I'll just take you through what is it, the MLI and its purpose. It says it intends to eliminate double taxation with respect to taxes covered by this agreement. Now, this is very important. Without creating opportunities for non-taxation or reduced taxation through tax evasion or avoidance, into brackets, including through treaty shopping arrangements aimed at obtaining relief provided in this agreement for the indirect benefit of residents of third jurisdictions. So treaty shopping, which was given the cover of jurisprudence in Azadi Bachao, is now watered down because of this preamble, which is embedded in the MLI. And once the MLI gets embedded into the domestic law by modification of the treaty, provided that it is a covered tax agreement, and India and the other treaty partner have accepted this. And this is one of the most basic conditions which has to be adhered to for it to be a covered tax agreement. So what is the significance of this what is the significance of the preamble? So the explanatory statement to the BEPS, that is Base Erosion and Profit Shifting Action Plan 6, says this clear statement of the intention of the treaty partners that appears in the above preamble will be relevant to interpretation and application of the treaty. So you cannot now use the treaty according to this explanatory memorandum and even the explanatory statement to Article 6, whereby now it is made clear that the intention of the parties is to avoid double taxation, but it is at no point to be used for double non-taxation or to evade taxes. And therefore, the inclusion of this statement, even the explanatory statement of the MLI states that it should be that it is the intention to clarify the intent of the parties to ensure that covered tax agreements be interpreted in line with the preamble language foreseen in Article 6.1. So in the landmark judgment of Azadi Bachao, the Supreme Court had given its decision by even including by taking the A of the preamble, because the preamble stated that the India-Mauritius ETSC, Double Taxation Avoidance Convention, recites that it is for the encouragement of mutual trade and investment. And this aspect of the matter cannot be lost of sight of while interpreting the treaty. However, now to curb this practice of treaty shopping, whereby residents of third countries to take advantage of a favorable treaty, let's say between India and Malta, India and France, India and Mauritius, or India and Singapore, set up shop in that country only for the purposes of taking benefit of that treaty. The preamble says that including through treaty shopping arrangements, aided obtaining reliefs provided in this agreement for the indirect benefit of residents of third jurisdiction will not be allowed. That is not our intention or purpose. Now jurisprudence will evolve on this as we go forward, and the MLI now will be interpreted. So when the MLI gets incorporated into the treaty through a covered tax agreement and gets assimilated into domestic law under Section 90, subsection 1, jurisprudence will evolve. So what are the other aids to interpretation? You have the OECD and UN model conventions and commentaries. You have parallel treaties, you have protocols, technical memorandum, international case laws, and preparatory work and circumstances of its conclusion. So these are some aids to interpretation of double taxation avoidance agreement, of treaties, and part of public international law. So as far as India is concerned, there is reliance. Jurisprudence has seen both taxpayers and tax administrators put a lot of weight behind the OECD and the UN commentary. But India's position is also there in the 2017 OECD commentary, where we have given our reservations. Then there is this static versus ambulatory approach. So general meaning as of today, jurisprudence says, yes, we will rely on the OECD and UN modern commentary, provided it is within the context of the treaty, and therefore it is recommendatory in nature, but not enforceable in law and binding. So widely accepted guide to interpretation. So the commentary to the OECD Model Tax Convention clearly states that it is not a legally binding document. However, in India and abroad, globally, various courts across the world have accepted this, the meanings given to the words of the treaty in these commentaries. But the tax authorities, as well as the taxpayer, should apply such commentaries after carefully analyzing and considering whether the commentary is in line with that particular DTAA. So later, later commentaries after the treaties have been entered into may enlarge certain meanings. So what we have to see is whether that was the purpose behind the treaty. Does the treaty language allow you to take that wide encompassment of the commentary? Is something which is debatable and which will only progress through litigation, or jurisprudence will give us more clarity. While the commentary may not be legally binding, it can be referred to for a reasonable or correct interpretation of a term of the treaty if the intention of the two sovereign nations are so aligned. So, what is India's position? So, in the OECD Model Commentary as updated in 2017, it includes the position of India, where India says we have certain reservations. So, India may not agree to a particular interpretation of a particular article as given in the OECD commentary. And therefore, it reserves the right to either amend the article itself or not to give that particular interpretation and include or exclude some aspect of the definitions given, amend amend the articles in its tax treaty. So it reserves that right. So basically, let's try and understand what is the meaning of this reservation. So it's an executive position. It's not the position of the parliament. So the union says so that's the government, that is the executive, says that we do not agree to certain interpretation of the OECD commentary. We may not agree to certain interpretation of the UN commentary, or we may believe that our interpretation, which is this and this, is the better way to interpret the article. That is our position, not of law, but of the executive. Remember that. So what is this binding nature of India's position? So jurisprudence says at best it only has persuasive value. And reference may be drawn while interpreting the treaty to India's position, where it reserves non-application of a particular commentary, but that will also depend upon the context of the treaty. But as we discussed, both taxpayers as well as tax authorities liberally quote the OECD and the UN Model Convention. So, what is India's position regarding OECD model commentary? They've generally accepted them as an important aid for interpretation. But where India has made significant reservation, India believes that a term not defined in the treaty can only have the meaning assigned under the domestic law. When I say India, means the executive, not the parliament. So Indian courts have relied on the OECD commentaries, and they have also said and commented upon these reservations. So in ITO versus Wright Flores, what does the Calcutta Tribunal say? So it says India's reservation on the OECD commentary, I'm reading it out because it's important, are relevant only to the extent of that OECD commentary and cannot be treated, this is very important, as a fair index of intention of the government of India and as contemporaneous exposition. That means it is not contemporaneous exposition of the treaty in respect of tax treaties entered into by India after so expressing its reservations. In fact, in Wright Flores, it goes to say it has no role in judicial analysis because it's an executive position. And more recently, the Delhi Tribunal has also held that while the OECD commentary may not be safe to rely upon, the same can sometimes be referred to for understanding some technical explanations. But India's position is best explained by the Supreme Court in engineering analysis, where it relied on news skies and say, this is important, a change in the executive position cannot bring about a unilateral legislative amendment into a treaty concluded by two sovereign nations. So India and let's say country X, let's say UK or US signs a treaty. India goes and says that we reserve our right to say that this interpretation as given by the OECD commentary is not as per our understanding of the treaty. Does it have any force? Answer is no. Does it have persuasive force? Maybe if the context of the treaty allows it. Otherwise, no. And therefore, the Supreme Court goes to say that even if that intention is cast in the domestic legislation, it cannot widen the meaning of the treaty till the treaty is amended. This is the crux of India's position and very important. Even let's take some foreign rulings. The Spanish Supreme Court has also ruled that you cannot interpret an earlier treaty on the basis of a later OECD commentary, where the definition of the terms in the treaty and the model convention are materially different. Means the context is completely different. So maybe as thought processes evolve, as commerce evolves, as business evolves, OECD commentary also changes. You have now the BEPS program. They are trying to grapple with digital taxation. So you have this global minimum tax, and you have pillar 1 and pillar 2. So these are grappling of tomorrow. Does it affect interpretation of yesterday? Answer is no. Yesterday's treaty is to be interpreted as it is. But maybe if the OECD commentary, later commentary, gives some more enlightenment without changing the context, you may still use it. So it says, in another case, in Netherlands, for example, and in a Spanish case, that posterior commentary may be important for supplementary means. It's an aid to interpretation, provided the text of the provision is as close as possible to the OECD Model Tax Convention or the treaty which you have entered. So even the Supreme Court of Canada held that despite revised commentaries sometimes diverging from the original intention of the parties, they are not applicable. All subsequent commentaries cannot be rejected in a prima facie manner. Have a look at it. If it is within the context of the treaty, courts may take into account such interpretation if it is beneficial to the and it is the intention of the parties. So that is for the courts to read into. So they are a helpful complement to earlier commentaries in so far as they elicit some different type of interpretation rather than contradicting views previously expressed. So if it does not materially change the interpretation of a term of a treaty, but throws more light, then it is like more knowledge, shedding more light. But if it is contradictory, then you cannot use it. Now we have this static versus ambulatory approach of how do you interpret a treaty considering the domestic tax law as given by Article 3.2 of the Model OECD Convention. So the static interpretation says that change in the incorporating statute not to have effect to an already existing treaty. So that means domestic tax law now, for example, defines royalty under 916 in a more extended manner. Can it affect how royalty is to be interpreted under the treaty? Answer is no. So similarly, in Siemens' case, change in domestic law is if it is so radical that it actually amends the treaty itself and widens its scope. Such change, if permitted to be used as an aid to interpretation under Article 3.2, would completely be wrong because it would lead to unilateral amendment to the tax treaty. That means India believes that royalty is now to be interpreted in this particular manner and widens the scope. And to that extent, such ambulatory approach is not to be allowed. So the ambulatory approach is that changes made in the definition also to be considered, that is definition on the day on which the treaty is being applied. Because the words are at any time in Article 3.2 and also in para 11 of Article 3 of the commentary. So ambulatory interpretation, they say a useful reference can be made to revised OECD commentary while interpreting a previously concluded DTW. I believe this is controversial, but let's see what happened in Reliance Geocom. So in Reliance Geo Infocom, the taxpayer, that is Reliance, contended that the sum remitted to the Singapore AE for provision of installation and bandwidth services was a standard business practice and did not fall under the definition of royalty. What did the revenue say? That we will take the ambulatory approach and we will see the definition of royalty now as per the domestic law, which is not the correct way to interpret a treaty. As we have already discussed and imbibed, that interpretation of a treaty and interpretation of domestic law is vastly different. So therefore, they concluded the ITAT upheld the decision of the CIT appeal, which said that treaty provisions cannot be interpreted via the domestic law amendments because it amounts to treaty override and contrary to interpretation of Article 26 of BCLT, which says it has to be done in good faith. And therefore, what it was paid was not for transfer of any technology, standard business practice, and therefore it is coming within the scope of business profits and not a royalty. So parallel treaties means, for example, India has signed different treaty with someone. Can you use those terms there? So the normal methodology is that sometimes you may rely if it does not change the context of the treaty. And even in Azadi Bachao, they to look upon whether Mauritius treaty would allow or not treaty shopping, they looked at the limitation of benefits article under the India-US treaty. So it's an aid to interpretation. It is recommendatory. It is not binding. What are the other aids to interpretation? Protocol, exchange of notes, relevance of unilateral material, and are such documents publicly available? The Bombay bench in NGC networks went on to say that an unilateral interpretation of the treaty, like the technical explanation by the US tax authorities of the India-US tax treaty, is not binding on us because it is not something which India has agreed to. So therefore, this decision is important. Unilateral things done by sovereign nations cannot affect the interpretation of an agreement which has been negotiated and agreed upon. That is the principle that is imbibed. Now, this is very important. So we'll spend some time on the most favored nation because this is most litigious and most controversial aspect. So what is the most favored nation clause? It emanates from actually the World Trade Agreements. The concept of can be traced back to the World Trade Organization. And what does it say? It does not want to discriminate between two treaty partners. So under the WTO, it says that if I give some concession to a third country, I will give that concession to you also. Where both treaty partners agree that if either of them gives some concession to another treaty partner, then that treaty also, that treaty partner will honor it also within that particular treaty. So what is the significance of the most favored nation clause? That one country under a treaty with India extends certain benefits of favorable treatment to another country, it shall extend the same benefits to countries under other treaties. So this clause gets triggered when India enters into more beneficial provisions of a double taxation avoidance agreement with a third country. And it is aim to avoid discrimination and maintain parity in business between various treaty partners. So let's say, for example, let's take the India-France DTAA, which had the most favored nation clause, and therefore state A binds itself to state B, that is France, that if it gives a more favorable treatment to state C, either by way of scope of taxation or rate of taxation in case of certain sources of income or the distributive articles of the treaty, as we saw earlier, that is royalty, fees for technical services, interest, dividend, and other streams of income, capital gains, then India will give that treatment to France. So what is the controversy? Let us try and see the controversy. When is it applicable and who has to be the third nation? These are the two talking points of this most favored nation clause. So what are the certain factors which would be relevant to determine the application of the MFN? Date of applicability. When does it apply? Very important. Is it the date of notification issued? Then the status of the states in case of the beneficial tax treaty. So the status is to be taken when? When you are applying the treaty or the most favored nation clause, or when the treaty was entered into with the third nation. And nature of income. Which nature of income is covered by the most favored nation clause? Mostly it would be dividends, royalties, fees for technical services, etc. And how are the benefits provided? Either with reduced rate of tax or reduced scope of taxation. So this most favored nation clause has always been a matter of dispute between revenue and taxpayers. Why? So for example, India, so the case that came up before the Supreme Court, I'll just give a little background. India entered into various treaties with Netherlands, France, and Switzerland, which contain the MFN clause that provided beneficial treatment to those countries when India entered into a subsequent DTA with another OECD, with a member of our OECD country, and certain concessions are granted. What type of concessions? Either regarding rate of tax or scope of tax. So India then signed treaty with other countries, Slovenia, Lithuania, and Colombia, who were not OECD countries at the time of signing of the treaty, but became later OECD countries. This was important. So now let's see how jurisprudence evolved. So jurisprudence evolved initially, whereby various high courts held that once there is an MFN clause embedded in the treaty and India enters into another treaty with another OECD country, and they applied it widely to say that that OECD country means when you apply the MFN clause. So even if when they entered into the treaty, originally that country may not have been an OECD member country, but later on when that treaty is applied and the MFN clause is applied and it is an OECD member country, then that concession should be granted. So the Delhi High Court in the case of India, France said that if the MFN would apply automatically, that is what they said. Why? Because the treaty is already embedded with that particular MFN clause, and therefore a protocol is not required to give effect to the MFN clause. So that was the most important thing. So what did they say? Protocol is considered as an indispensable and integral part of the treaty and does not have to be again separately notified. So if India and France have entered into a protocol which says that the most favored nation clause should be given to taxpayers of France when India enters into a more beneficial treaty with another OECD member country, it is automatic. And this decision had been followed by Karnataka High Court in the case of Apollo Tyres and even by the Delhi High Court in the case of Concentric and Nestle. So this is the controversy. So what is the controversy is that if there is a provision in the treaty or in the protocol entered into which allows the MFN clause to be applied, you do not require any separate notification at a later date for the MFN clause to kick in. So that is the crux of these decisions. And you don't have to see whether the whether that country was a member of the OECD at the time when sign the treaty, you have to see it when the MFN clause is applied. So this was the contention. This was what the jurisprudence laid down, and this was how the assessees or the taxpayers interpreted. However, the CBDT came out with a circular on 3rd February 22 to say, wait, 1 minute. They say that if a treaty, even if it contains the MFN clause, but if that advantage with that third country is to be incorporated in the treaty, a separate notification is required. Very important. It said that. And it also clarified that when a treaty is signed with a third state, such state has to be a member of the OECD at the time of signing the treaty. And it must have signed after the treaty with the first state. Means like France, I sign an MFN clause, India signs. When I enter into another treaty with, let's say, a OECD member country, then it is okay. But if I enter into a treaty with a third country, which is not an OECD member country, has got certain more concessions, and then later on it becomes OECD member country, then the CBDT circular says that that beneficial provision of the treaty does not apply. And the circular clarified that any decree, bulletin, or law passed by the other contracting state is an unilateral decision if it is not passed along with negotiation with India and has no legal enforceability in the courts of law in India and has no effect on the tax liability under the DTAs. So when this case, all these cases went up to the Supreme Court, what are the questions which were there? There were two main questions. Can the MFN clause be applied automatically? That is, whether certain concessions as regard the scope of tax or rate of tax can be applied to the treaties under dispute. And what is the interpretation of the term is a member of the OECD at the time of signing the treaty with that third country, or later on when I apply the MFN clause, I can apply that and say that no, it has become a member of the OECD country. It is now an OECD member, and therefore those provisions are applicable. And which incomes were under dispute? Mostly it will be FTS, royalty, dividend, and interest. So what did the Supreme Court say in Nestle? Very important. It makes some significant interpretation issues. So I think the ruling does not have only effect for MFN clause. It also will have great effect on how you interpret a treaty under the Constitution of India. So it discussed all the rulings which we discussed, Nestle, Concentrix and all. And therefore, the ruling analyzes the MFN clause on two bases. Whether the MFN clause can be invoked when the third country with which India has entered into a ETA was not an OECD member but became a member later on. And does the MFN clause apply automatically? So the contention of the revenue is very clear, or was very clear, that the power to enter into treaty is the power given under Article 73 read with various schedules, is given to the union or the executive. But Article 253 says that any treaty to be embedded in the domestic law has to be legislated. So for example, let's say that if section 90 subsection 1 was not there on the statute and India enters into various treaties, how will they get assimilated into domestic law without section 91? They would never get legislated. They would never get assimilated. So that is why section 91 says that when these treaties are notified, they get assimilated into domestic law. And to the extent that the provisions of the DTAA are more beneficial than the provisions of the treaty, of the domestic law, then the treaty applies. And from where does this assimilation took place? This assimilation took place because the parliament passed section 90 subsection 1, which is embedded in our Income Tax Act. And therefore, it says, this is an important principle, that it distinguished India as a country following a dualist practice, which meant that treaties did not get automatic assimilation into municipal law without an enabling legislation, which is the notification which is issued under section 91. And therefore, the revenue relied on section 91, which requires separate notification, and also stated that he is a member of the OECD, has to be interpreted as a requirement when the treaty is signed, not at a future date. Contention of the assessee was the opposite, that if there is an MFN clause, it should automatically apply, and that once under section 90 a treaty is notified, then you do not have to notify again the MFN clause to incorporate the benefits of a third country treaties which gives lower rate of tax or a reduced rate of tax. And the assessee rebutted the revenues argument is a member of the OECD to mean not a continuous requirement, but only a requirement when I apply the MFN clause. What does the Supreme Court say? The Supreme Court states that both Article 253 and 73 are clear that the treaty provisions are enforceable in Indian domestic law and they are binding on courts and tribunals only when the provision gets assimilated into domestic law. And therefore, the Supreme Court held that that a notification under 91 to give effect to the MFN clause is a must requirement. And if a country wants to claim the benefit of the MFN clause as a result of India entering into a treaty, it has to be a member of the OECD when it enters into a treaty and not at a future date. This was the provision of the law. So this judgment now will have far-reaching consequences for MNCs because MNCs have taken benefit of the jurisprudence which was available at that time, remitted monies at lower rates of tax. So then what will be the effect of this ruling? It's going to be mind-boggling. So how will the revenue interpret the Supreme Court judgment? What will this judgment apply retrospectively? Whether past concluded assessments can be reopened? What about penalty provisions? All these are debatable things. In fact, the Delhi High Court has followed now this ruling, and the SLP has been not yet admitted, but the appellant has claimed, Harish Salve has claimed that certain important aspects of public international law have not been properly argued. And the main argument was that a unilateral practice of a state, that means of notification, at that notification will, whether it can influence treaty interpretation, unilateral practice. And therefore, at the time of signing the treaty, the government has a play. But once the treaty is signed, then you don't require any assimilation of the domestic law. Actually, treaties have been interpreted by the Supreme Court in very many earlier cases, which is given in Nestle's judgment, which one can read. We don't have the time to get into that. So some of the important judgments are, for example, State of West Bengal versus Jugal Kishore More, Tractor Port versus Tarapur, and I think the important one is the Privy Council's ruling in Maganbhai Ishwarbhai Patel's case, which followed the Privy Council's ruling in Attorney General for Canada, where it talks of the play of Article 253, 73, and the assimilation of a treaty into domestic law to make it binding. Many MNCs have reportedly received notices of demand of staggering amount of 11,000 crores. A review petition has been filed against the Nestle judgment to interpret it as per the VCLT. And the Finance Ministry has also been urged to come up with a amnesty scheme. And now we come to MLI. I'll just quickly run through MLI. We are running short of time. So what is this MLI? The MLI was introduced as part of the BEPS framework. It conventionally, treaties could be modified or amended only through a protocol, or you renegotiate a complete treaty. But MLI aims in swift modification of the tax treaty. India is a signatory to the MLI, and as of January 2024, there are 102 signatories to the MLI. So the action plans are which are part of the MLI are these hybrid mismatches, treaty abuse, PE, and dispute resolution. And these are given in these various articles, whereby the treaty is modified. And options are given to countries whether to opt for a particular position or no. And some of the articles are compulsory, like the preamble article, for example. So what are the important points to be kept in mind is that are both the countries signatories to the MLI? That is first thing. And have they deposited the instrument with the Secretariat? And whether that particular treaty is a covered tax agreement, and what positions have both the treaty partners taken as regards the options given under the treaty. So therefore, what are the 5 steps for applying the MLI? Entry into force, covered tax agreement, reservations, notification, and entry into effect of the MLI. So what are the important points? Both contracting jurisdictions should have signed and ratified the MLI. The signed copy should be deposited with the OECD Secretariat and notified the track treaties to be modified by the MLI. So the important points are when does the MLI come into force? What is the relevant date and entry into effect? So the relevant date is later of the dates on which the MLI comes into force. That is first day of the month after the expiry of 3 months. And the relevant date is for withholding taxes the next taxable year, and for other taxes 6 calendar months after the relevant date. So let's take the India-UK DTA, for example. So the instrument was ratified on 29 June 18, and therefore it became into force on 1st October 18. India ratified in 19, and therefore it came into force on 1st October 19. So the relevant date is the latter of the 2 dates, so 1st October 19. So therefore, from an Indian perspective, the withholding taxes would apply from the next taxable year, that is 1st April 2020. And similarly, the effect of taxes also, other taxes would also apply from 6 months after 1st October, that is 1st April 20. While in case of UK, withholding taxes, because they follow the calendar years from 1st January 20, and corporation tax 6 months afterwards, after 19, that is 1st April 20 or 6th April 20. So what are important things? That the MLI does not amend the treaty. It exists alongside the treaty and only modifies the treaty. That is what the explanatory memorandum says. So there are minimum standards and there are some optional provisions and there are compatibility clauses. So what does the MLI do? It either applies in place of, in absence of, or applies to or modifies an existing treaty. So as far as India, UK is concerned, these are some of the places, articles where both have accepted, while in other cases they have not accepted. So where they have not accepted, it would not apply. And then what is a synthesized text? Where this MLI provisions are given in the treaty. So now India has come out with synthesized text. OECD also says that a synthesized text helps in understanding the treaty, but it's not a legal document. But what is the real legal document is the existing treaty, the MLI, and the positions taken by the treaty partners. So India has signed this, have this many text. Important part is that after the Nestle ruling, a Swiss company has stated before the court that the anti-fragmentation rule, which is there in the India's Switzerland treaty, would not apply because it has not yet been notified under Section 91. Important nuance. Let's see how it develops. Now, the Mauritius government has said that the India-US treaty will be a covered tax agreement. And ICA has also released the technical guide on WEP's action program. Thank you, friends. I hope it was something which we all will learn, because I believe the more you share knowledge, the more you learn. And thank you very much for the time. Thank you to Piyush and ICI and the other members on the panel, including and Mr. Singh and Rani and everyone. Thank you.
Thank you very much, sir. It is definitely a thought-provoking session. It gives us confidence to open the treaty and read it, which most of us, we don't have the confidence to open a treaty and read because we don't understand the language. It definitely is an impetus to open the treaty and read. We have some questions. Most of the things you have addressed. Some little more detailed questions which I would like, which is a subject of this session, because some of the questions I see may not be a subject for this session. It is more on the interpretation of respective articles. One question which you have just touched upon, it can be a continuum to what you discussed just now. India has a treaty with 122 countries, including comprehensive, limited, and synthesized text. Please summarize the conceptual difference between them. Just now you had a concluding remark on that. So perhaps our understanding is the existing treaties with all the details of income and the application of articles for the respective income could be the comprehensive treaties, and synthesized text will be appearing in the comprehensive treaties when the country has entered into an MLI. And limited purpose treaty, understand India has a limited agreement, limited treaty with Pakistan. That is my limited understanding. You can just give your inputs on that, sir, please.
Yeah, so therefore, as we discussed earlier, you have comprehensive treaties which cover the full gamut of taxation, and you have limited treaties. So depending upon which treaty it is there, to that extent it will apply only to those particular aspects of taxation. In a comprehensive treaty, as we discussed, it covers most sources of income. And when an MLI is entered into, the important part to understand is whether it's a covered tax agreement, what is the position taken by India, what is the position taken by the treaty partner. Some of them are compulsory, like preamble and all, which we have discussed. But the positions which are taken, if they are contradictory, then they don't apply. So if India says that, for example, anti-fragmentation PE rule of the MLI particular article will apply, and the other treaty partner says no, then that provision does not apply. And later on, they say that later on the treaty partner can change their position. So you have to read the comprehensive treaty alongside the MLI. So, for example, now most countries have accepted that when a company, that means a person other than an individual, is a resident of both countries, then the place of effective management used to be taken under that particular Article 4. Now they say that no, what you have to take into consideration is that both competent authorities taking into account effective management, country of incorporation and other relevant matters will decide in which country does that particular entity reside and is a resident of which country. So you have to read the MLI as a modification of the treaty. It is not a protocol. It modifies the treaty alongside the treaty. So the treaty provisions remain and the MLI positions remain. And then the MLI replaces those positions in absence of or for that or in replacement. That's the way you have to read the MLI. And only jurisprudence will tell us how you read the MLI. But today you have to read the MLI alongside the treaty. existing comprehensive treaty.
Thank you, sir. Another question, again on MLI. Could you please help me with the recent MLI by United States, whether they were issued after the abolishment of the dividend tax?
So what context is that question? So for example, the US is not a signatory to the MLI. So if
MLI, yes.
so US will have to renegotiate treaties with all the countries to bring in the provisions which it believes is useful, and the other treaty partner means India will have to agree to that amendment. So therefore it's not a signatory to the MLI.
Just to add to what Vishnu has explained, that along with the tax treaty, you have to read, the MLI, and the synthesized text of a treaty is the one which puts both India, Japan has come out with synthesized text. So that eases, the reading of the tax treaty.
So you have to read the tax treaty holistically. And most important, remember, the synthesized text will give you what is the position of the other treaty partner and India. So therefore, it's not a legal document. The correct way to interpret the treaty is to see that article of the MLI, see India's position of the MLI, and then interpret the treaty along with what is the position taken by the other treaty partner. So the basic document is the MLI, not the synthesized text. The synthesized text is only for the ease of reading. It's a little complicated. You have to see covered tax agreement, position of India, position of the other treaty partner, see whether how it is to be applied in place of, in replacement, in absence of. That's the way we have to read the MLI. Mr. Singh, interesting, no?
Yes.
But complicated, highly complicated, no? Correct.
Could you please explain the concept of limitation of benefit clause?
Yeah, so the limitation of benefit clause is like an anti-avoidance clause that third parties should, or residents of third jurisdictions should not take advantage of a favorable treaty between India and another country. So therefore, to see whether that particular company or person has substance, so there is a limitation of benefit article which says that if you don't have a particular level of economic substance, that means you are not eligible to the beneficial provisions of the treaty. So only genuine persons having residence of that country and fulfilling the terms of the limitation of benefit article can apply the beneficial provisions of the treaty.
Okay, thank you, sir. Next question is about, I think this is already there in the domestic taxation. You can give your insights, sir. If the India does not have a treaty with a country, how shall we go about getting a double taxation relief? I think Section 91 is the answer.
Yeah, Section 91 will give you the relief.
Yeah. Next is a very, it is asking, is the long-term capital gain computed in India will have to be considered or recomputed again under the US tax rules? Perhaps somebody has a double tax impact. So whatever capital gain which has been, I think this question is relevant because in India, when you file a tax return, we might claim exemptions under Section 54, sir. I think that is what the speaker wants to ask. I'm not so sure, but I think this is what he wants to ask.
No, the
In
point
India,
is,
when the tax return is...
no, Rani, the point is very clear.
Yeah.
If an American citizen earns
Yes.
capital gains in India, he pays tax according to the domestic law. To the extent that the domestic law is relieved by the TTAA, he will get relief. That's all. And whatever taxes he pays in India, he gets credit in the country of residence. And the computation mechanism for domestic law may be different from Indian source rules.
So the taxpayer credit will have a relevance, sir, here.
Pardon?
whether the tax paying credit will have an impact
But
here
that
because he enjoyed,
taxpaying,
let's
no,
say,
you
an
are,
Indian resident.
we should not confuse two concepts. No, you have to see the treaty. If there is a what type of relief from double taxation is given. Either it will be a credit method, exemption method, or tax sparing method. So I don't believe that in capital gains you will have any tax sparing. Tax sparing is actually nothing else but aid by the developed country to the developing countries. Very few treaties have tax sparing.
So another question is, how does the existence of a DTAA impact the tax planning strategies for multinational corporations, and what considerations should be taken into account when advising clients on cross-border taxation transactions? How does a country determine the residency and eligibility for benefits under DTAA?
That's a general question. How you will answer, Mr. Singh? Huh? So
The
I
only
will tell
answer
you.
which can give is that rehear the presentation by Wispy. He has in fact addressed all the points which has been raised, Rani, how the residency rule will be applicable and things like that. So one has to read through that. I mean, both the provisions, the tax.
I'll just
Uh,
try and attempt to give some answer. So when you advise any client, you have to see what is the transaction, where does he reside, what is the advantage of the treaty which is available, what is the economic substance of the transaction, can you demonstrate that he's a resident of that particular country where you want to take advantage of the treaty. And now there is this controversy about this TRC also. You must be aware of it, that recently the in the case
In
of
fact, there is a question on that also, sir.
yeah, so in the case of Blackstone, the courts had held that once there is a effective TRC, then the department should not go behind the TRC and you should accept the TRC, that is the tax residency certificate. But the Supreme Court has stayed that order. But recently, in the case of Norwest Venture Partners ex Mauritius, it is a very recent ruling in 2024. The tribunal relied still on earlier decisions like Azadi Bachao and said that once there is a TRC which is given, you cannot go behind it. So though the Delhi High Court decision had been stayed by the Supreme Court, the tribunal gave decision on the basis of another ruling because because when the Supreme Court stays the operation of a particular ruling, that does not mean that it has stayed the operation of other rulings. Only that ruling has been stayed. So therefore, this controversy will continue, that how do you determine whether you are a resident of a country and is TRC a reasonable basis or no? Now, this is something which two countries have to negotiate, I believe. And therefore, we have answered
Can we take
most of the
two
queries now,
or
Mr.
three
Singh.
more questions?
Okay. All right.
One or two questions more can we take, sir? Do we have the time?
If there is time, I don't mind one or two questions.
Can we take one or two?
Because I think
Yeah.
I have
Indian
spoken
company.
for a long time now. Okay. Continue.
Yeah.
You can
So
ask.
last question, sir.
Simple
Last
question, yeah.
question. Indian
Yes, yes.
company.
Yeah.
Indian company received a dividend from its 100% subsidiary in Singapore in assessment year 1920. Indian company did not file Form 67 due to which tax credit was disallowed. So what is the remedy available? I know it's not the subject of this session, but
This is not a
if you are
subject of
experienced,
our topic. No, it's too
yes,
specific a query. We have to look into the facts of the case before we can even give someone advice like this. And
yes.
never take advice of us in a seminar like this and apply it. Otherwise, you may land yourself in some bigger problem. So therefore, you have to only
Yeah,
see
sir. So
if, for example, you have not filed your return, what is the way out? I do not know. We'll have to study the case. No, but not something which we can
yes.
answer on the panel. Okay.
Yeah, sir. I think the rest of the queries, most of the things you have covered in your discussion, sir. There are no specific queries which we have not addressed. So to summarize your session, some of the bullet points which I could gather from your session, I think it will be helpful for all of us. Treaty is a contract. It is not a. It is an agreement. It involves negotiation. So the principles, some of the principles which we have to remember when we interpret a treaty, the scope of the treaty is relevant, and treaties more generally worded. Interpretation basically should take care of the considerations based on which the treaties were negotiated. That is very important when you take the application of the treaty, and interpret the treaty in accordance with the ordinary meaning to be given to the terms of the treaty, and significance of the preamble, and the relevance of and role of the commentaries in interpretation of the treaties. These were the matters which were discussed. Unilateral decisions taken by the sovereign countries cannot affect the treaty provisions, and protocol is considered indispensable in the interpretation of the treaty. Then MFN clause, very important point. The country should be an OECD member at the time of entering into the treaty. And treaty, the coin word, I think the treaty is a language of the diplomat and not language of the draftsman. That gives a summary and substance of how to interpret the treaty, sir. Thank you very much for a very valuable session. As I told you, any student or any practitioner of international taxation with today's session will get really a confidence to open the treaty and read it, which is very, very critical in the study of international taxation. Thank you so much for such valuable sessions, sir. And thank you, ICAI, for giving me this opportunity to be a part of this session. Definitely, I may not have I may not have attended this session because I would have missed this session. Thank you so much. Special thanks to Kota Srinivas, who gave me this opportunity, and wonderful session, sir. Thank you. Thank you very much.
Yeah.
Thank you. Thanks, Visby.
Thank you, Mr. Singh. Thank you, Piyush, Mr. Kota, Rani, Rudriksha, and Priya, and everyone. And wish all the participants that you have gained something today, because I have gained by sharing my knowledge. Thank you. Thank you.
Thank you. Yes.